Now I'd like to talk to you about something that, if you're watching this, I'm terribly sorry because you've probably lost a loved one. And that nobody should have to learn the law when it comes to wrongful death. And nobody expects that they will ever be in a situation where they have to understand what happens when I've lost a loved one and somebody has caused their death. If it's not a criminal action where the district attorney would pursue, and that's defined as murder, you may feel like this rises to the level of murder. But the only distinction between the criminal action and what is defined as a civil action is intent. And when somebody acts carelessly, recklessly, and negligently, and it results in the death of somebody else, there's no intent involved, although it may feel like there was intent. Because how can somebody act so recklessly such that it results in the death of another? But the law does allow you to recover and hold the wrongdoer accountable. And the type of case that is called is a wrongful death lawsuit. It's called wrongful death because the death was wrongful. It never should have happened. Somebody died before their time. And it's important for many reasons to hold the wrongdoer accountable. I have had the tremendous honor of handling many wrongful death cases. My office has handled over 2,000 wrongful death cases for which I personally have been actively involved in many of them. Each one is unique. Each one takes on a special purpose. Each one is defined by the loved ones that are left behind. Because the purpose of a wrongful death lawsuit, in my humble opinion, is not about the money. It's about working towards closure. Not that you'll ever forget your loved one. Not that you'll ever miss those good times and this will replace it. But it's about doing what you believe is the right thing to do. And ultimately, every individual makes their own decision as to what will bring them closure. Sometimes not bringing a lawsuit at all brings closure. And I tell every client, don't feel because your loved one died as a result of someone else's recklessness, carelessness, or negligence that you're compelled to bring a lawsuit and hold them accountable. There are people who, to bring closure for themselves, need to move forward. And you must know that starting a wrongful death lawsuit and pursuing a wrongful death lawsuit, it slows down the natural grieving process. Because there is a process with respect to losing a loved one, and that process is particularly hard when it comes as a surprise. And you have to do some soul searching to decide and answer the very first question. Is it the right thing for me and my family to pursue the case? Take time to make that decision. But once you've made that decision and you've decided it is the right thing because we must hold this individual or this corporation accountable for what they've done and the tragedy that's occurred, then I strongly encourage you to go all in. Make sure you add every part of what you need to communicate as to what was taken from you. Because at the end of the day, that's what will ultimately bring you closure. The outcome of the lawsuit isn't what's going to bring you closure. Because at the end of the day, a wrongful death lawsuit can only do one thing: get a money award. And nobody would ever replace money for the loss of the loved one. So you need to understand going in, the most that can occur is a financial award. I'm certainly not minimizing that, but it does not bring closure in and of itself. I have handed millions and millions of dollars to people every time I do, and the larger the amount of money on that check, I ask a very simple question. If the day before this event I told you that in 2, 3, 4 years from now you'd be sitting with me and you didn't know me, and I'm going to hand you a check for X amount of dollars, but this is what you need to go through. Tomorrow, your loved one has to be in a catastrophic event, has to die. You have to go through the stress of a lawsuit, the depositions and every component with respect to the lawsuit. And I've done another video with respect to all the steps of a lawsuit. Please feel free to look at that. But once you go through all of those components, and at the end of it, the insurance company ultimately agreed to pay X amount of dollars, and here's your share, would you do it again? The bigger the number, the louder people say, absolutely not. So it's not a windfall ever. And wrongful death cases is never a windfall to recover that money. But what the money often does is bring closure, bring some peace to the heart when you know that you've stood up for your loved one and did everything that needed to be done to hold that wrongdoer accountable. But when it comes to damages in a wrongful death case, and when I define damages, that is, what is it that you're eligible to recover for? What is the loss? It may seem self-evident. Well, my loved one died. I'm entitled to the loss of my loved one. Well, the law in each state differs as to what and I'm going to define who can bring a lawsuit in a moment, but what you can bring the lawsuit for. Every state differs. So I will limit my discussion today. Well, actually, what I'll do is I'll talk a little bit about New York law and then other states, what you're entitled to from other states. But first, let me talk about who is eligible to bring a wrongful death lawsuit. Here, too, it's state-specific. Most states, not every, but most states require that a legal entity bring a lawsuit. And the legal entity is called an estate, E-S-T-A-T-E. An estate must be created to stand in the shoes of the person who died and bring the lawsuit for their estate. The process to create an estate is state-specific. Depends on certain filings. Was there a will? Was there not a will? If there is a will, the will does define who the administrator of the estate is. One thing that people often are unclear about is an administrator of an estate does not define who gets what. They don't have the power to divvy out and distribute monies willy-nilly. They must follow, if there is a will, that which is proscribed in the will, which is defined in the will. All a will does is define the assets, how they should be distributed of the person who passes to whom. If somebody dies without a will, the state defines who gets what assets. So if there's a will, the individual who has passed has taken the time to define how they want their assets to be distributed. If there is no will, each state defines who receives what. So, as a simple example, if somebody passes without a will, it is clearly defined: are they married or not married? Are there children? And how many children? So, in a very broad way, generally, if somebody is married, the spouse is eligible to receive 100% of the assets of the spouse who has passed. This is without a will. If they have no children. If they have one child, then the assets that the spouse that has passed generally are split 50-50, and that's defined by the state. If there's more than one child, the surviving spouse, receives 1/3 of the assets, and the children then share the balance, what's called per capita. Each child gets the same equal amount no matter how many there are. So if there's 2 left, they would get 50%. If there are 3 children, they each would get 1/3. If there's 4, 25%, and so on. There's many permutations and different ways all of that can go, but that's generally if somebody passes without a will. And if somebody passes with a will, the will define it. There's one caveat I will add. Most states protect a spouse. So if somebody is married, even if they have in their will written out their spouse, they're not allowed to do so, and their spouse has a claim for generally at least 1/3, but often 50%. So, but the will generally define how the money will flow, and it's not the administrator doesn't have the ability to change any of those instructions, whether it's by will or deemed without a will by the state. All the administrator does is empowered to now execute on the instructions of either the state or the as defined by the will. So the administrator of an estate is also empowered to bring claims that the estate may have on behalf of the estate. And when I use the term estate, that really is just the legal entity that is created when somebody passes to distribute all of the assets that that person had. So if an individual, very simple, had a car in their name and they pass, that car then becomes an asset of the person who passed estate, and the administrator is then empowered to give that car, and it's not a gift, but distribute that car to whoever was defined to receive that car, and the administrator is empowered to sign the title over to the new person. So when I use the term estate, it's simply I'll define it as a holding bucket of assets for when somebody passes. And the administrator can then distribute that which is in the estate. Well, some of the assets that are in somebody's estate aren't always tangible. It's not always money or a home or a car. An asset of an estate is also claims. And a claim that can be made on behalf of the estate for the benefit of what is called the beneficiaries of the estate. So when somebody receives something from an estate, in law, they are defined as a beneficiary. They benefit from the estate. So the administrator has an obligation to maximize any of the assets of the estate and distribute them according to either the will or the laws of the state. When somebody dies as a result of a wrongful death, that is, that somebody else has violated some law, or they've acted recklessly or negligently and caused the death of another, their estate can bring a claim for all of the losses. And this is a little confusing sometimes, but there are actually two different parts of a claim in a wrongful death case, and I'm going to keep them completely separate. One is a claim that is the individual who died, their individual claim from the moment of the event until the moment they have died. That is called pain and suffering. That is a claim that is not a claim of the estate, because it didn't, and the legal term is accrue. It didn't start until the individual passed or died. So that claim is an individual claim for conscious pain and suffering from the date of the event until the date they have passed, as well as any economic loss, their lost wages or the cost of medical expenses that may have been incurred from the date of the event until the date of death. That is one claim. Once the individual has died wrongfully, then there's another claim for the estate from that moment, date of death, moving forward. And that's the wrongful death part of the claim. So there's two separate and distinct claims from moment of event until time of death, and that is the individual's claim, and although they have passed, the administrator is empowered to bring and make those claims. And then separate and distinct are the loss to the estate. And basically, if the individual had not died, they would have continued to contribute and build an estate, build whatever it may have been, if they were working or whatever assets. That loss is a separate and distinct claim. So I want to keep those two buckets separate for a moment. The first bucket, which is from the moment of the event until the moment of death, is actually the easier part from a legal perspective claim to be made, because that is often based on what witnesses have observed, and there are medical records, and it's very clear what the wages were from the moment of the event until the time of death, and the medical bills are very clear. The doctors submit the medical bills, and simply an eighth grader can add up what those medical bills and lost wages were. And then the pain and suffering the individual had from the moment of the event until the time of death, that then can be evaluated by a jury. If the individual who passed was married, the spouse, the surviving spouse, also has a separate and distinct claim for what's called loss of services during that period of time. Anything that the deceased, now deceased spouse was providing during that period of time, there also, the surviving spouse did not receive those services during that period of time, they're eligible to recover an award for those loss of services. That is prior to death. Now, after somebody passes, what are the claims that are eligible in a wrongful death case? This is where it's very state specific. This is where some states recognize that after somebody passes, the hurt continues, the harm continues. And who does it continue with? Those that loved the individual who passed. The family members, surviving spouse, children, sometimes grandparents, parents. Every state defines who is eligible to recover and what they're eligible to recover for. So I'll give the two extreme examples. Some states allow for recovery for all of the hurt and all of the harm and pain that the family members are enduring after this wrongful death. And they can put forth and tell their story to a jury as to what the person that they've lost truly meant to them and their grief and their sorrow. And certainly that's the most humane states allow that. Because when somebody passes, the estate and the people that are left behind are the ones who are really thinking and always evaluating the what ifs. There are other states that don't recognize that loss at all, and New York happens to be one of them. New York has a wrongful death statute, and again, what I'm talking about is what is the estate eligible and who can recover anything. The wrongful death statute was originally formed in New York, I believe, in 1841 or 1842, somewhere 1840s. And the law has not changed in the state of New York since. And the law, when it was originally crafted, New York was an agricultural state. Every place was farmland. And what the law wanted to recognize, and at the time, children worked on the farm right on through, and there was no such thing as retirement back then. The world was much different. And the New York State legislature at that time determined, well, all we need to do is have what I define as replacement value. What is the value that the individual that was died wrongfully, what were they providing as services to the farm, and let's replace it, because now, rather than have a farmhand working, doing whatever it may be, you now have to hire someone. So what is the cost related to that? And it's strictly an economic evaluation. There's no recognition, unfortunately, for the grief and the loss as relates to the family members. Now, I want to caution you. Most lawyers in New York will say, well, you can only recover the economic loss because that's what the law says. I would suggest to you those lawyers are not astute on what truly happens in the courtroom, and they haven't truly read what's called the charge that a judge gives a jury. What is that? The instructions of law, that is what is recoverable. It's covered in what is defined as the pattern jury instructions. Pattern jury instructions are what the judge instructs the jury as to what you can recover. And I have them right here. And I'm going to highlight for you what most lawyers overlook. And I think it's good to hear this so you understand at the end of a case what ultimately is read to a jury. And as I read through this, you'll hear the distinction between the conscious pain and suffering of the individual, the first bucket, and then the second part, the wrongful death, which is the loss of the estate. So a judge would read at the end of a trial, as you have heard, the plaintiff is, and the administrator of the estate, is the representative of the estate for the decedent. The representative makes two claims. The first claim seeks damages on behalf of the distributees, the beneficiaries of the estate, resulting from the death of the individual who died, and the second claim seeks damages for the injury suffered and losses sustained by the individual who died before he or she died. You must separately consider each of these claims. As to the first claim, which relates to the estate and the distributees, damages are the amount that you find to be fair and just compensation for the monetary losses resulting from the decedent's death to each of the persons for whom this claim is brought. Those persons are, and then the judge will list the decedents. Most lawyers stop at that because it says very distinctly compensation for the monetary loss. Monetary loss is lost wages and economic loss. But I'm going to read and I'm going to highlight for you why many lawyers err on that. The administrator claims that these individuals have sustained monetary loss as a result of the decedent's death. In that, and then it asks to outline what are those monetary losses, lost wages and so on. The law limits damages resulting from the decedent's death to monetary injuries. You must not consider or make an award for sorrow, mental anguish, injury to feelings, or for loss of companionship. You must decide the monetary loss to the distributees caused by the decedent's death on, and you give the date of the death. In deciding the amount of monetary losses, you should, and this is where I want to highlight for you, because jurors are humans. They're instructed to limit it to monetary loss, but what is included in monetary loss, which I'll define right here. In deciding the amount of monetary losses, you should consider the character, habits, and the ability of the deceased person, the circumstances and conditions of the people that were left behind, and this is the magic words, the services that the decedent would have performed for all of those people, the portion of his or her earnings that he would have spent or she would have spent in the future for the care and support of these individuals, the age and life expectancy and the ages and the life expectancies of the people who have left behind. And here are the magic words. And the value of intellectual, moral, and physical training and guidance and assistance that the decedent would have given the children had he or she lived. Now, would you read that again? The value of intellectual, moral, and physical training, guidance, and assistance that the decedent would have given children had he or she lived. There's no set dollar amount with respect to that. And there's no limitation on ages. It says 2 children. Recently, I just handled a case on behalf of a family. It was a terrible tragedy. A 79-year-old gentleman was caring for his wife who required medical care, and he would take her every week for this particular medical care. He's walking through a parking lot and somebody backs up out of their spot, just runs him over, drags him, and he ultimately passes later that day. He leaves 3 adult children, all in their 50s. He leaves grandchildren, ranging in ages from 5 to 23. And he leaves his wife. His wife passed 10 days later. She lost the moral guidance, assistance, and support during the last 10 days of her life. A jury is asked and is entitled to define what that is. What is it to have the love of your life with you in your dying days? What is it to lose the guidance that your parent provides, no matter how old you are? That is not defined, but it is a monetary loss. And even in the state of New York, if your attorney handles it the right way, they can, and I don't mean this in a derogatory way, backdoor in all of the things that New York ignores, because they specifically ignore that which is the true importance of the case. They specifically ignore, and I'll just read, you may not consider or make any award for sorrow, mental anguish, injury to feelings, or loss of companionship. So if a skilled attorney understands what I just shared with you, loss of companionship is not compensable. You cannot get an award for that. But loss of guidance is compensable. So if it is simply framed as the loss of guidance, I relied on my father when I was having challenges with my teenage child and would talk to my father or mother with respect to it, and I've lost the guidance on how to address that, that's compensable. But if it is framed as, boy, I really liked my dad, especially when we talked about how to handle a teenage child, that is not compensable because that would be considered companionship. So a skilled lawyer, and I hope I'm empowering you to challenge your lawyer, don't accept that it's only a monetary loss in the state of New York, because the statute, in fact, does allow for more than just lost wages, because the law in the state of New York is frankly discriminatory. All it does is benefit those who are wage earners, and it's completely discriminatory for those who are not, because the law specifically says for monetary loss. So if an individual, you take two exact individuals at the same station in life, they're both 45 years old. One happens to be a large wage earner, and one happens to be a homemaker. The law technically favors the wage earner when the homemaker, and we all know, is providing the greatest services of all, caring for children and maintaining stability. Yet the law doesn't recognize that. But if you have an attorney who understands how this law is presented to jurors, you still should be able to fully recover. And let me just add one last component with respect to wrongful death. I just want to read the specific charge or the instruction to the jury on how those services are valued. So a judge would read to the jury, in fixing the value of the decedent's services, you must take into consideration the circumstances and condition of his or her spouse and children, the services he or she would have performed for the spouse and children in the care, management of the family home, finances and health, the intellectual, moral, and physical guidance and assistance he would have given the children had he or she lived. In fixing that monetary value, the decedent, to the survivors and children, you must consider that what it would cost to pay for a substitute for his or her services, considering both the decedent's age and the life expectancy of the children. So what is the cost for the substitute services of the guidance that you lose when you lose your loved one. I don't think there is a value at replacement cost, but ultimately a jury will decide that. And if you have a skilled lawyer, you should be able to get full compensation, and the most important thing, get closure. Thank you for watching the video, and I hope you found it informative and were watching for your own knowledge as opposed to because somebody had a catastrophic event that you love. But if somebody did, I do encourage you to find the right expert lawyer to help you because experts and lawyers can provide tremendous guidance and help you through a tragic event and loss of a life and let you know whether or not you can hold the person who did this to your loved one accountable. In so doing, it's important to find the right lawyer, and if you have any questions along that line, you can always reach out to my law firm. We'd be happy to help you find the right lawyer. I know lawyers throughout the country. I've taught many lawyers throughout the country. So we'd be happy to assist you to help you find the right lawyer. Lastly, you should always remember that cases like these have very strict time frames to bring a lawsuit. So although you may be grieving, it's something that you should take action because I would hate for you to lose the opportunity to hold the wrongdoer accountable, and that would only happen if the time frame was allowed to run out. And just a couple suggestions when you do think about retaining a lawyer, some things to always keep in mind. It's important that the attorney that you consider hiring is somebody who listens to you as opposed to lectures you. Listening is a really important quality that you want in a lawyer because they need to not just hear what happened, but hear how it's impacted on you. And if they just start talking and saying this is how it's going to be, it's not likely there's somebody who is a good listener, and it's very important to have a lawyer who understands what you've gone through and then can communicate that well to an insurance company or if need be to a jury. Secondly, you want to make sure that they provide you with all the necessary information for you to make an informed, educated decision, because at the end, that is the role of the lawyer, to educate you so you can make a smart decision. It's not the lawyer's case, it would be your case and one that you make the decisions on. The lawyer's job is just to inform and educate, not to decide. So empowering you to make that decision is something that you want to be listening towards when you're interviewing lawyers. And lastly, when you're thinking about hiring a lawyer, you want to make sure that that first phone call is free. Lawyers who work in this area work on what is called a contingency. That is, they only receive a legal fee if they are successful in representing you. If they're not successful, they receive no legal fee. And the competent lawyers in this area never charge a consultation fee simply to have a conversation to see if they can help. So with those little suggestions, I wish you good luck. I'm attorney Andrew Finkelstein, and thank you for watching this video.